Hi, I wanted to respond to DaVinci 15's video that he made about somebody sending him an email regarding a trademark infringement. And you can tell from what's going on here in the video, I'm going to mute it, that this person, Whippalock, has some sort of trademark or claims to have a trademark on his name. Fundamentally, trademarking your name can be a little bit tricky because, you know, your name is your name and it's used in common usage. So you're trying to take a word out of common usage or the public domain and protect it from anyone else using it. And you can do that, and there's limited grounds for doing that. But in this particular case, I just want to address what DaVinci was looking for as far as what do I do about this? You know, what's wrong with what I've done? And so I think it's best to examine the defenses of the Lanham Act, which is one of the primary defenses, especially here on YouTube, is using your fair use defense. So here I'm going to go ahead and go over to PowerPoint. We'll do a quick overview of what trademarks are. Trademark itself is a device which, used in course of commerce, serves as the exclusive function of identifying the source of the goods or services to the consumer. It can be words, symbols, fragrances, color, sounds, overall appearance of a package. All this can be trademarked. Essentially, the mark attaches to the product, and the mark refers back to the source of the product. That's what a trademark is. It's to identify the source of a product in commerce. And when people claim that you're infringing on their trademark, what they're saying is that there is a likelihood of confusion of the source of the product, which means that perhaps you have another product, you're using a same or similar trademark, except it's your product, which means that a consumer could be confused about who exactly produced the product. And what the real problem is unfair trade practices is the underlying theme of why we have trademark laws, because if you are allowed to just use anybody's trademark on your package or product, then what you could be doing is free riding or coattailing on other people's work that they've done to produce not only the product, but identify the products as theirs to the consumer. So that's where the likelihood of confusion comes in. If the average consumer could be confused as to who's the producer of the product, then you have confusion. The products also need to be used in commerce, and since this is a federal law, commerce in this sense is talking about interstate commerce and use of the Commerce Clause. So it would have to be connected to interstate commerce. I'm not going to go into a whole discussion about that. We could go on for hours about that. So just so you know, that's how it's run. And this is how infringement is found about trademarks. Now, fair use defense, really when you're talking about trademarks have two meanings. They have the meaning of the mark, which is used to identify the source of the product in interstate commerce, and then the surname or surname, which is the descriptive meaning of the mark. And I know those are kind of difficult to parse out in your brain exactly what that means, but basically you can't take words out of the public domain and just say, I now have this as a trademark. It needs to be actually attached to a product. But if you happen to have trademarked a word that may be used in the common vernacular of our culture, then what happens is somebody's using that word as its regular descriptive name and not as the trademark name, then you're just using the word, and it's fair to use it in that way, i.e. fair use. So you have two types of fair use. Descriptive fair use: defendant, i.e. the alleged infringer of the trademark, is free to use the mark in its strictly descriptive capacity to describe her own product or its geographic origin, or to identify its producer. Then you have your second form, which is nominative fair use, applied when a defendant has used the plaintiff's mark to describe or refer to the plaintiff's product. It permits the unauthorized use of the plaintiff's mark to identify or describe the plaintiff's product as long as the use does not attempt to capitalize on consumer confusion. Mainly, I think we're dealing with nominative fair use in this context. Just my opinion. I'm not an attorney. This is not legal advice. I'm just imparting knowledge. The three factors to determine whether which will be used by a court to determine whether you're actually can employ the fair use defense are this. The plaintiff's products must not be readily identifiable without use of the plaintiff's mark. So it's necessary to, use the mark to identify the product. Okay, so you can't call, for example, everybody inline skates, commonly referred to as rollerblades. Rollerblades is a trademark of a particular type of inline skate because it's hard to describe inline skates without calling them rollerblades. You may be able to call it, a type of inline skate, a rollerblade, and thereby you're using the trademark, but only to describe the product itself, the plaintiff's product, in this case, rollerblade. The second factor is defendant may only use it so much of the plaintiff's mark as reasonably necessary to identify the product. And the third factor is defendant must do nothing that would, in conjunction with the use of the mark, suggest sponsorship or endorsement of its product and the trademark owner. Sorry about the typos here. So, in essence, the court's going to say, hey, were you trying to coattail on basically the goodwill of his business and try to steal his business by using the mark and confusing people into buying your product? That's what this is all about. Now, the result of the nominative fair use analysis is it acknowledges and accommodates others' interest in referring to a particular product by its identifying mark for purpose of comparison, criticism, parody, or the like. I think right here we're dealing with criticism or comparison, and really you're allowed to use these trademarks in certain contexts in order to to talk about the product itself. There's nothing wrong with that. It fits squarely into nominative fair use. I think that's what's going on here, and Da Vinci shouldn't be worried that this person would actually have an actual a claim against him. However, going back to his video, if we scroll back a little bit here, see if we can get. Okay, we see Weblock TM at Met Downfall Society. What I would do here is I would take out the little TM symbol, okay? Not because you're not recognizing that it is a trademark. Well, what you're saying basically is, hey, I'm a response to, or clarify this title, say a response to Weblock's blah, 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 the rest of his title. That way you can't be confused. Your video can't be confused as sponsorship by Weblock of what you're saying. And that's what Weblock is, Weblock, or whatever his name is trying to impart to you that, hey, I'm worried about you using my name and people are thinking that I'm endorsing what you're saying. I don't want you to do that. So just make it very specific and clear, and also, and I've seen this in other videos, make a fair use disclaimer in your video right up front. That way you don't have any issues. Last thing I wanted to point out here is these are your two citations. If you're going to be using a fair use defense, this is the actual law that you'll be using in order to substantiate what you're saying and why it's fair use. So KP Permanent Makeup Inc. versus Lasting Impressions. This is where the Ninth Circuit actually laid out the nominative fair use defense and its elements. So everybody referenced this when they're saying when they're using a nominative fair use defense. And defenses to trademark can be found in, this is the Lanham Act, and this is the particular section 1115b4 where the defenses are found. So I hope this is helpful. Wouldn't freak out about that email, and just make sure to respond and possibly change the headline of your title and include a fair use disclaimer. Hope that helps.